Good morning. This is the clerk of the court, and it is 10 a.m. in Washington, D.C. Judge Greenberg, the conference is configured for oral argument this morning with recording and live video streaming now up and running. Counsel are prepared to argue, and all participants are ready to proceed.
Very well. You may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable William S. Greenberg presiding. God bless the United States and this honorable court.
Okay. Good morning. This is Judge Greenberg, and I'm joined by Judge Meredith and Judge Jaquith. We're convened today via video conference to consider arguments in the matter of Ripley and Butler against the Secretary. Will counsel, beginning with Petitioner's counsel, please make your appearance.
Good morning, Amy, Heath, and Kathryn Cahoy on behalf of Petitioners.
Thank you. And would you like to reserve time?
Yes, Your Honor, we would like to reserve 10 minutes.
Very well. Now for the government, please, your appearances.
Thank you, Your Honors. Ronen Morris for the Secretary, and with me is Christopher Wallace.
Thank you. All right, counsel for the petitioner. Go ahead.
Good morning, and may it please the court. I'll first briefly touch on each of the petition, the motion to dismiss, and class certification before turning to the issues in more detail. As to the petition, the Secretary has a statutory and regulatory obligation to furnish application forms to veterans who submit an intent to file or request for application. But he doesn't send application forms in response. He sends a letter with directions to go find the form online. That letter goes to everyone, even though the Secretary knows that a significant percentage of veterans lack internet access. Furnish means more than make available on the internet. As this court recognized in Montalvo and in Haino, it incorporates the concept of receipt, getting the forms into the hands of veterans. And so any practice that the Secretary adopts to fulfill his furnishing obligation has to involve delivery in a manner reasonably calculated to be received. As to the class of claimants that petitioners seek to represent, which is those who submitted an ITF or an RFA by paper or orally, that group opted against beginning the claims process online. They have not consented to communicate with the Secretary through the internet, and the Secretary has no indication that they can do so. And as a result, the Secretary's current practice of mailing a letter with a website address is not reasonably calculated to get application forms into those veterans' hands.
Just a minute. I hate to interrupt you, and we haven't gotten to that portion of the argument yet, but do you have any idea how many people we're talking about? That is, veterans who either decline to use or have no way of using the internet, and the only communications they'll receive from the Secretary are thus by mail, presumably.
We do not have a sense as to that number. Based on the statistics that the Secretary provided, he said about 60-something% submit an intent to file through starting and saving an e-benefits application. And so that would leave 30-some% who begin the process through either a paper form or orally. And so that number we think is definitely in the thousands, likely more than that.
All right, thank you. Go ahead with your argument.
Yes, thank you. So turning now to the motion to dismiss, the Secretary's current practice burdens those claimants by forcing them to take extra steps beyond what the statute and regulations require to actually obtain application forms. And that extra burden is an Article 3 injury that the petitioners here had incurred at the time that they joined the suit. The picking off and inherently transitory exceptions to mootness apply to allow them to continue to pursue their claims, even though the Secretary mailed them paper applications after they joined this case. Turning to class certification, the Secretary's primary argument—
Can I interrupt you there?
Yes.
In your response to the Secretary's motion to dismiss, I read your pleading as providing two alternative methods as to why the petitioners had standing. One was what you just said, that VA's practice creates an additional burden on someone to go seek out the form. But you also said that VA's practice creates an imminent risk to claimant's ability to access benefits. Are you walking away from that argument, or do you continue to press that?
We would continue to press both arguments. So it is both the burden that they present an injury either way. Either the claimant has to take extra steps to go get the application form, or they face a risk of losing benefits or of losing their effective date because they do not have the form, and so, you know, cannot proceed along the path to.
So to clarify, as to the two named petitioners, when they joined this action, are you saying that they specifically were at imminent risk of not being able to access benefits? Or are you talking more generically that some veterans might be at risk of not being able to access benefits?
I would say that the imminent risk would apply to everyone in this situation who is not provided the application form that they need. And so in this particular case, these petitioners joined the case, got counsel, joined the case, and so did end up receiving the application forms from the secretary as a result. So they took on that extra burden, but had they not done that, then they would have been at risk, or had the secretary not provided the forms, they would have.
Can you walk us through that for the two named petitioners? Your argument turns largely on access to the internet. Do the two named petitioners have access to computers or the internet?
So those facts are not in the record. I do not know whether they have access to the internet. Our argument about burden and about imminent injury do not depend on the individual facts of each claimant's situation.
So I'm trying to get to what I just asked you is, are you contending that these two named petitioners were at imminent risk of not being able to access benefits? So to that extent, their individual circumstances are, I think, incredibly relevant. So as to whether or not they had access to the internet, I'd point you to your November 2021 fee agreement with the petitioners that you entered into with each named petitioner, and it contains this language. It says, you agree that both you and our firm may use electronic devices and internet services to communicate with each other. You agree that the benefits of using such technology outweigh the risks of unauthorized disclosure. Does that suggest that the two named petitioners here did, when they joined this action, have access to electronic means of communication?
So that is standard language that is in our firm's retainer agreements with all clients. And so I do not think that can be read to suggest that these particular claimants necessarily have access to the internet. But even if we're going to move away from the imminent risk of injury, these two petitioners did take on a burden. They do have an Article 3 injury because in order to get the application forms, they joined this suit. They had to take steps beyond what the statute and the regulation require. And so,
well, the burden is a different question, I think, than whether they're at imminent risk of not being able to access benefits. And on that regard, I have another question. Do you know each of these named petitioners, they submitted to VA a paper copy of the intent to file form? Do you know how they accessed that?
I do not know how they access this. I believe they each named VSOs. And so it could have been through the VSO, but I do not know off the top of my head.
Does your firm communicate with them electronically with the two named petitioners?
We communicate with them by phone.
On the other question, that you suggested that there's an additional burden because the two named petitioners had to seek out the forms. As you just mentioned, the evidence that we have before us suggests that both were represented by a VSO when they joined this action. Why would the petitioners themselves have had any obligation to go seek out the forms themselves if they were represented by someone whose job it is to help them prepare their application forms?
Well, I think just because that they are represented by a VSO, they still, the statutory obligation is on the secretary to furnish the forms, and that is his obligation, whether they are represented by VSOs or whether they are proceeding independently.
But
And
we're
so-
talking about harm here. What's the harm to the two named petitioners if they did not themselves have to seek out the forms because they were represented by a VSO?
Well, the VSO did not provide them with the forms, and so they joined this suit to challenge the secretary's failure to provide them with the forms. And that extra step in their case is an extra burden. And so as to the secretary's response generally as to other claimants is, you know, they can call, they can pick up the phone, they can drive to their nearest regional office. But in both this court's decision in Rosinski 2 and in the Ninth Circuit's decision in ALDF, those courts recognized Article 3 injury when a claimant was either denied a statutorily required means of accessing information, or when they had to go around, take a different method towards achieving the same result. That extra burden in both of those cases, the court recognized, is an Article 3 injury. If I could, I would like to turn to the merits, the issue of the statutory duty to furnish. The secretary, Congress decided to put this obligation on the secretary to furnish the forms. And this court, as I said in my opening, has previously interpreted furnish to incorporate the concept of receipt. And so any method that the secretary chooses to fulfill that obligation has to be reasonably calculated to ensure receipt. And this is the same analysis that the Supreme Court looks at in the procedural due process context. And so in cases where it requires actual notice, such as before depriving someone of property, the analysis when you're looking at does a practice as a whole comply with an obligation of actual notice is it reasonably calculated? And so when we're looking at the secretary, is it reasonably calculated to ensure receipt as to a class of claimants who he has no indication that they can or are able to access forms on the internet? It is not reasonably calculated for him to just mail them a website and say, go online, go find this yourself. And that's particularly the case when he knows that as of 2016, 21% of veterans' households lacked access to the internet. And
Ms. Heath, doesn't the statute require a request by a claimant to trigger the secretary's obligation to furnish the hard copy forms and instructions?
It requires a request, and that request, the secretary, as part of the rulemaking process, laid out the intent to file process. And there's also the request for application. And so when claimants or petitioners have filled out a complete intent to file on the form prescribed by the secretary, they have made the request for the application. And at that point, the secretary is obligated to provide them with an application in response.
And it's at that point that instead they get the standardized letter?
Yes, it's at that point, instead they get the standardized letter. And it's also worth noting that the letter itself contains no indication that a paper form is available upon request. It contains no directions as to if you need a paper form, do this, that, or the other thing. It says the secretary will take no further action on your application until you submit a complete application. go to this internet website to access the form. There's no indication that there is another way to get a paper application for those who need it.
And so would specific information on the standardized letter about VA's willingness to provide printed hard copy forms and instructions on how to request them afford claimants adequate notice and a meaningful opportunity to pursue benefits?
We would say that it would still not meet the Secretary's furnishing obligation because it would be requiring claimants to take an extra step in order to get the applications when they have already done everything that the statute and the regulations require. And so it would certainly be better than what the Secretary is doing right now, but we don't think that it would be good enough to meet the statutory obligation. One option that we've proposed instead in our briefing, and we're not trying to dictate to the Secretary how he should run his operations, but for example, if he were to add a line to the intent to file form that says, I agree to access my forms online, or please send me a paper copy, that would allow him to have the information necessary to know this group of claimants, I have the information that they are able to access online. They're good with that route. As to these other claimants, they do need a paper application, and that imposes no additional burden on claimants. And so that would satisfy, as an example, that would satisfy his statutory obligation.
What about a claimant that doesn't check either the opt-in or the opt-out box?
We would say, as for those claimants, the presumption should be that they need a paper application because, again, unless the Secretary has some kind of indication that they have consented to online delivery, that the presumption should be paper. And that's similar to how a range of other government processes, private industry operates. If you think about the court and its ECF system, if you think about how a bank operates, the presumption is they're going to mail you your paper statement until you say, no, please give it to me online. And so this is not some sort of new process that we're proposing here. It's something that's widely available in a range of other circumstances.
But if the notice specifically says, just say so, call, click, or write, and we'll send you printed forms to fill out and instructions on how to do so, rather than the general information that's there now, is the burden of saying so still too much to bear?
Yes, that burden of making them do something beyond what the statute and the regulations require is too much. And that I've already cited the Rosinski 2 and the ALDF cases. We would also look to Beltran and Hernandez cases that we cited in our briefs. And they say that the Secretary or the agency cannot read additional burdens into what is contemplated by the statute. And so in the Hernandez case, for example, the statute says a certain class of aliens is entitled to both work authorization and documents to demonstrate that work authorization, and INS was making them separately apply for the documentation. And the court said, no, you cannot make them take that extra step. They are already entitled to it. You need to give it to them without forcing them to take on an extra burden. Because I'm running down. Oh, sorry. Did you have a question?
Well, I wanted to ask, back up a second and ask a question about the mootness limitation. If the court denies class certification, is there any exception to mootness that would apply to the named petitioners?
I see. So you're saying if the class denies class certification, are both of the exceptions that we've invoked dependent on there being a class?
Right. That's the question.
Okay. Yeah, I believe the inherently transitory exception would still apply because when the claim is not expected to last long enough for the court to adjudicate the claim, there would still be the same type of mootness issue where the if it's not expected to last long enough for the court to adjudicate the claim, and you are seeking prospective injunctive relief that would still apply even if your claim is moot. So here they're seeking a change to the secretary's practice that would apply more broadly. We would say that exception would still apply.
Well, assume for a second that it doesn't, that it only applies in a class action context. There is a similar exception. I think it's called the capable of repetition but evading review exception that can apply in an individual context, but it has some requirements. And the first of those is, what's the reasonable expectation that the same complaining party will be subject to the same action again? Does that apply here?
It could apply here. It is conceivable that someone could apply for one type of benefit, go through the process with that type of benefit, and then later apply for a different type of benefit. And so it may be for different benefit types, but you would still be encountering the same problem. And so to that extent that you might expect it to, the same claimant to face the same problem on a repeated basis, that exception could also apply.
Anything else, Judge Jaquith?
I had one more question on the class issue, and that is, what does the Federal Circuit's SCAR decision last Thursday do? How does it affect your proposed class definition?
So the significance of the SCAR decision, I guess I would make a few points. One is that the court there held that because of this court's statutory jurisdiction, it cannot include future claimants. We would say that this case is distinguishable because here the jurisdiction being asserted is under the All Rights Act. And so it is not necessary for this court's jurisdiction that someone has gone all the way through the process of getting a final board decision. And all of our class members are in the same position with respect to the All Writs Act. So to that extent, I think SCAR would not affect our class definition.
Well, wouldn't it at least knock out the from whom the secretary receives an intent to file or request for application in the future?
It could knock out the people in the future, but as to the currently existing people, and people would be added to the class as they submit an intent to file. So you might rephrase the class definition in that sense, but as to the bulk of the class, the currently existing class, it would not have an effect.
Thank you, Judge Greenberg.
Mm-hmm.
All right, and Judge Meredith, anything further for counsel at this point?
On the question of mootness, I think you acknowledged earlier that the petitioners, the two named petitioners, did actually receive paper copies of the application form back in December. Has either petitioner filed an actual claim to this point?
They have not yet.
Are you aware of any barriers that they face in filing a claim?
I am not aware of any barriers at this point after they've received the paper application. No.
Thank you.
All right, anything further? Thank you very much. Did you want to say something else? You did reserve time.
I was just going to say I will reserve the rest. Thank you.
All right, thank you very much. All right, we'll hear from the government.
Thank you, Your Honors. May it please the court. Your Honors, the petitioners here are seeking redress for an injury that doesn't exist on behalf of a class that they're not a part of, based on pleadings that are riddled with irregularities and premised on legal arguments that range from the facially absurd to the wholly unsustainable. And what's more, Your Honors, what they demand not only doesn't align with their arguments, but it has the potential to negatively impact millions of veterans impede the department's efforts to modernize and improve the claims process for all, and generate vast amounts of needless waste. And Your Honors, it is likely antithetical to the interests of many of the very veterans in whose name they claim to speak.
Just a minute. Thank you, Counsel. How so?
In which regard, Your Honor?
The last regard, the argument you're making that it'll adversely impact millions of veterans. How will it?
Because, Your Honors, the petition demands that all claimants automatically receive paper applications. That's the demand made in the petition. If every claimant receives paper applications, more claimants will use paper applications, and paper applications are indisputably an inferior method. The Secretary has attempted and has made great efforts to improve the claims process, and I would suggest that veterans as a whole want a better claims process. And part of that is the creation of e-benefits with the Department of Defense, and that not only benefits the individual veteran using it by guiding them through the application process, by allowing them to upload documents, and many other benefits, such as communicating with their physicians or applying for other ancillary benefits. But it also improves the process as a whole, the more veterans who use it. And the reason being, because it reduces the time that it takes to go through claims and to process and adjudicate claims. It reduces the risk of loss, especially the risks of loss that are associated with paper files. It reduces the need for resources to be allocated towards scanning and inputting systems. So the more veterans that use the electronic claim submission process, the more beneficial it is for everyone. And again, if you start off by automatically giving all veterans paper applications, you are going to see a reduction in the use of the electronic claims process.
My concern is not so much the format, but it's the substance of the content. Excuse me, I would look at this argument more in terms of what is it that's not a real burden to the Secretary to supply to the veteran as to what precisely they're supposed to submit on their own behalf to get the benefit they seek, rather than at least a two-step, maybe a three-step or more process of, okay, if you want a benefit, you've got to ask for this or that. And the average veteran without assistance has no idea as to how to do that. That's my assumption. You can correct me if I'm wrong.
Well, Your Honors, and I don't want to simply skip over the issue of standing, but to address this point, which would go to the, I suppose the merits of the petition, I do have several points. And the first, Your Honors, is that any method of delivery requires some effort on the part of a veteran. Even when documents are mailed, they are not delivered with the envelope opened, with the documents placed on top and put on someone's table, Your Honors. So there's still that minimal amount of effort that somebody has to give, whether it's going to a mailbox, opening the letter, or going to a P.O. box. So there's always going to be something that the veteran needs to do. And I would suggest that clicking a button on a computer is actually probably less onerous than going to a mailbox, opening and sorting through paper copies, and then looking for a pen.
Well, wait a minute, just a minute, if I may. You're making a conclusion. You're stating a conclusion. Do you have any facts to back that up, that the electronic process is in fact more favorable to the veteran, more favorable to the efficiency of the department?
As the Secretary noted in his pleadings, these are claims that were made and substantiated in the Federal Register. But Your Honors, we're not here based on a challenge that it's not a more efficient system, and we haven't been given that opportunity, and we haven't been asked to provide the foundation of that. But Your Honors,
but you've been arguing it. You're arguing in that. I'm just inquiring as to the basis for the veracity, and I'm not suggesting you're misleading the court, but I want to know the basis for your conclusion that electronics are inherently more efficient and better for the veteran.
Well, I believe that the secretary did include some data about the reduction in backlog and case backlog that has occurred since the adoption and since the use of e-benefits. And as the use of e-benefits has increased and that backlog has also gone down, I think inherently, Your Honor, there is no risk of loss of paper copies. And as this court is well aware, there are inherent, there are issues and there are times where copies are lost, misfiled, and so on and so forth. So I think inherently, I don't believe that it's disputed that electronic systems are inherently better, that they also produce less waste because there is no cost associated with printing, which in this case would be over 70 million pages every year. The cost, the equipment that's used to print and scan, the postage. So, Your Honors, I think that there are some very clear benefits to the use of the system. But again, the interface style of e-benefits, to give an example, it guides veterans through the questions. So it's not an application that the veteran might inadvertently not complete or not provide the correct information. The interview style process guides them through the process to ensure that every application is complete and that all of the information that needs to be there is there. And so it reduces that risk that an application will be incomplete and sent back or not properly adjudicated. But, Your Honors, I think more so to the broader point, Your Honors, is that the Secretary's system is not based on requiring effort from veterans. From the very start of the system, those who cannot access forms online and are unrepresented and are otherwise need help, they're funneled into the system in a way that ensures that they are ultimately provided with the type of application in the form that they need. And, Your Honors, that starts with the intent to file, which I believe that Meredith noted a very significant point, which is, or implied it, which is that the forms that these petitioners filed are forms that are available online. Your Honors, those who don't have that access, those who do not have a representative or have that inability to access these forms that are made available online are given the options to submit an intent to file in other ways by calling either the National Call Center or any regional office, or by walking into a regional office. So inherently, this system is already at that first point of entry, that first point of engagement is designed to catch those individuals who don't have the electronic access. And they are, in those cases, specifically offered paper applications. But, Your Honors, to the extent that a veteran may slip through that crack, there are additional safeguards. And those safeguards include that automatically generated letter that's sent to every veteran that also not only provides, the instructions to how to access e-benefits or the forms online, but it specifically advises them to contact the agency if they need any help whatsoever. And it provides toll-free phone numbers, mailing, a way to contact by mail, a way to contact by email. So, Your Honors, that's an additional safeguard for those who aren't captured by the first funneling of the system. And beyond that, Your Honors, the system as a whole.
But Mr. Morris,
Yeah.
that standardized letter doesn't say anything about getting actual paper copy forms, does it? It emphasizes, as part of the efficiency plan that you described, VA's interest in incentivizing the use of e-benefits and electronic forms.
That is correct, Your Honors, but I would first note that this petition is not based on an inadequacy of notice or the idea that veterans are unaware that they can ask for paper copies. Certainly, neither of these petitioners have suggested that they were unaware, given their experience in the system, that they couldn't ask for a paper copy. And it is certainly not a part of the relief that the petitioners have requested. So, with respect, I'm not fully prepared to respond to the reasons why, but I would add that I am not aware that there is any confusion amongst veterans, that the call for any help does not result in the knowledge that they can ask for an application in a different form. And again, we're only talking about those veterans who manage to file a form that's available only online, and either they've done so because they downloaded it, or they've used a representative, in which case, as in this case, Your Honors, it is unclear why that representative wouldn't then, their obligation is to assist the veteran in completing a claim. So why they would not then do that without the actual refusal of the claimants of that service organization representative's help, or if they've gotten it from a regional office, they would have been asked if they wanted a paper claim, and so a paper application, and so they would have had to refuse it. So, Your Honor, we're talking about a system that's designed to capture these individuals, that provides these, that attempts to identify anybody who has difficulty in completing their application. It's the secretary's interest.
But as soon as you argue that, you get into the gradations of remedy that are available to the court. This does not need to be the all or nothing question that you framed it as, and to some extent the petitioners have too. There's no reason necessarily why the secretary's obligation to furnish forms means that every veteran has to be mailed a form. There may be a way to accomplish that short of mailing a form to every potential claimant. The question is whether the method that's been chosen by the secretary is adequate to fulfill that statutory obligation. Because I assume you're not arguing that the secretary's authority to make policy decisions that promote efficiency extends to decisions that contravene statutory requirements.
I am not, Your Honor, but I am also here prepared that this is based on a writ petition. This isn't a board's decision that denied benefits. This is a writ petition that was initiated by the petitioners based on specific arguments and looking for very specific relief, Your Honors. And that is why I believe that we are here. And the filing of the writ petition, respectively, should not give rise to a carte blanche ability to review every aspect of the secretary's system. And most significantly, Your Honor, is that because we don't even have that allegation of injury. And in this case, we don't have any injury at all, but we don't have an allegation of injury based on a lack of notice or the lack of ability to ask for a paper application. And this case was premised on a very specific allegation that the mere fact that the petitioners were not automatically given a paper application has injured them. And because that created an imminent risk that they wouldn't be applied for benefits, and because it required them to take additional steps. Again, additional steps are required no matter how something is furnished, unless it is hand-delivered and put directly in front of a veteran. And there is no imminent risk. In fact, Your Honors, there is no allegation here that either of the petitioners missed any deadlines or suffered any loss of monetary benefits. And in fact, neither have. And these are the interests that Congress sought to protect here. It is that entitlement to benefits, and neither have been denied either of those, Your Honors. And
is it the secretary's position that there are no other claimants besides the named petitioners who meet the proposed class definition? There's no one else similarly situated?
Your Honors, I would suggest, I believe that case law is clear that it is the named petitioners who have to have suffered the actual and concrete injury, and that these named petitioners are merely alleging a mere technical or procedural violation. They did not get something. It has had no consequence. In fact, these petitioners haven't even alleged that they're unable to complete their claims. And I would note, Your Honors, that I do actually believe that Petitioner Ripley did in fact complete his claim in January of 2022, and that he has actually been granted benefits, Your Honors. Even the original petitioner, Petitioner Murray, had completed the claim as well. So, Your Honors, we are talking about a purely hypothetical group of individuals who might have suffered something. They have not been identified. And I don't believe it's insignificant, Your Honors, that this litigation, this petition was filed in February of 2021. And the petitioners have not, or counsel or petitioners have not identified a single individual who allegedly did not apply for benefits, or who allegedly missed a deadline to apply and was denied any benefits in that more than 1.5 years. And it is perhaps also telling, Your Honors, that there have been no attempts by any organization to file an amicus brief in this case attesting to the existence of these individuals. So this is a purely hypothetical group.
Counsel,
and I will acknowledge.
Can I jump in there?
Yes, Your Honor.
As to the issue of standing and whether the two named petitioners suffered a harm, to what extent can we take into account that they were each represented by a veterans service organization at the time that they joined this action.
I think that is very significant. I think that there are other critical points, but I think it is very significant that they were represented by individuals or organizations that had an obligation to do the very thing that they are now alleging they have suffered as harm, Your Honors, which undermines the idea of causality, which is a specific component of standing, is that there any claimed inability to complete their claim, which they don't even allege that they can't. But to the extent that they might allege, well, they have that ability. They, in fact, have a representative, and that representative exists as part of the design of the system. I'll note one other point here, Your Honors, which is that the petitioners allege their injury. And even if we assume that there is some concrete injury in the mere fact that paper application is not provided, Your Honors, the petitioners, their intents to file were received on November 1st, 2021. They turned around and sued the government within 18 days of that, Your Honors. And so to accept that they were injured would not only mean that the secretary had to have furnished them with paper applications, but that he had to have done so within this 18-day period before they turned around and joined this litigation, because that was the date that the request to amend the petition was made. So, and this petition is not based in any way, Your Honors, on the failure of the secretary to timely provide paper applications. The injury, the only injury is petitioners did not receive immediately, in apparently 18 days, receive paper copies of applications, yet they have been given paper applications, and at least one of the petitioners, I do believe, did actually complete a claim based on that application. So, Your Honors, I don't see in this case how we even get past the question of standing, but even if we do, Your Honors, the mootness doctrine would seem to certainly apply, because again, not only were the petitioners given paper applications, but they were sent those paper applications as part of the very design of the system, which is that anytime a claimant indicates this need or a preference for a paper application, they're given one. This is simply a product of the system working. Your Honors, we are not here because the secretary has any rigid policies or rigid demands on anyone. The secretary's system is designed to ensure that all claimants have what they need to pursue their claim for benefits. And again, it's designed to identify those who may have special needs or may have special requests or special preferences. These individual petitioners, as the counsel is seemingly acknowledged, there's no disclosure as to how they received their intent to file forms. And in fact, it turns out that they got them from a representative who would have been obligated to help them.
Mr. Morris, what about the inherently transitory exception and the voluntary cessation exceptions to mootness?
Your Honor, I don't believe that either would apply, and specifically the inherently transitory exception wouldn't apply here, Your Honors, because the mootness occurred as a result of the very process itself, not in any way an attempt to evade judicial scrutiny of that process. The process is working. It worked now. It will continue to work in the future. There is no there's no prospect of an injury being repeated. If by design the secretary provides the very remedy that the petitioners are asking the court to order. And sorry, Your Honor.
Could I jump in there? You mentioned that one of the petitioners has since filed an application for benefits and you believe has been granted benefits.
That is correct.
Can you provide us any details as to the application that was filed? Was it done through the VSO or online? Was it mailed?
I believe, Your Honor, I believe it was on a paper application. I believe it is. I was not able to necessarily tell just with my, how it was submitted. I'm not sure if it was mailed or if it was electronically submitted. And again, Your Honor, this is based on my review of the files. But I don't even, I don't even think it's necessary to rest on that point. Because again, I don't think we get past the question of standing, and mootness occurs simply by virtue of the fact that the Secretary's process, as by design, provided the very thing that these veterans wanted. So Your Honors, yes, I believe that the ultimate disposition of this case should be granting the Secretary's motion to dismiss.
Mr. Morris, does the standardized letters limited general information constitute injury supporting standing by requiring the expenditure of time and other resources by those who are savvy enough to discern a path through the fog and possessed of sufficient wherewithal to go down it?
Your Honor, it is perhaps an allegation that could be made. It wasn't made here, though, and standing has to be premised on the allegation of injury made by the named petitioners in this case. If an allegation was made of an actual concrete harm, and in this case, Your Honors, I would still suggest that no concrete harm would occur until there was actually a loss of benefits or an inability to apply within the 1-year time period. Because even Petitioner Butler, that 1-year time period has not yet elapsed. So nothing legally could have happened to either of these petitioners at this point. So again, there simply is no injury. But yes, there are perhaps, again, hypothetical situations where one could allege an injury sufficient to get through the standing. Not that the Secretary necessarily concede the merits of that, but at least the allegation could perhaps survive scrutiny of the constitutional prerequisite to consideration of the merits. And again, Your Honors, here, even if we do get past these, get past the question of standing, again, the petitioners haven't demonstrated their rights to the issuance of a writ, nor have they demonstrated the lack of alternative, means for relief. And I'd suggest, Your Honors, that foremost, the easiest way to obtain relief is to do what the petitioners did, which is simply express the need for a paper application, and that relief is immediately granted. And again, it's granted by design of the system. And also, there is no reason to issue a writ in this case, especially, Your Honors, given the fact that there are potential dire consequences to the system as a whole and negative implications for all veterans if the use of paper applications is unnecessarily encouraged.
But Mr. Morris, that depends on the nature of, excuse me, of the grant of the writ. Excuse me. How does VA's standardized letter fulfill the statutory requirement to furnish forms? The letter doesn't actually furnish anything, does it?
And perhaps it doesn't, Your Honor, but neither 5102A, 3.150A, or 3.155A require the Secretary to furnish applications immediately on the spot the moment an ITF is received. It is simply sufficient that that obligation be carried, that the Secretary engage in his obligation, which he does, starting with intents to file when they are submitted by those who don't have internet access orally or in person, when they are there on the spot, offered the ability to obtain a paper application. So this form letter is simply a part of a process, and what it's meant to do is not to provide the application. It is not meant as a sum total. It informs the veteran immediately. It's auto-generated simply to let them know.
This is where your argument becomes circular, because you tell us the process isn't at issue here, but then you invoke the process as the means by which the Secretary fulfills its furnishing requirement. So let's talk about the process. Where's the notice and meaningful opportunity to participate in the process in the Secretary's standardized letter?
With due respect, Your Honor, that standardized letter, again, will only have an impact on those who specifically submitted an intent to file via a form.
Via any means at all.
Everybody gets that letter because everybody is encouraged to use e-benefits, and because it makes the location of VA's forms available to everybody immediately. But Your Honors, that is, it is not itself the totality of the Secretary's attempts or efforts to furnish applications. That effort starts
Well,
immediately.
so let's talk about the totality of those efforts and
Okay.
how they meet the statutory requirement.
The statute
How do
requires-
they?
Because veterans are provided with applications that they can either access themselves and download, that they can have in paper form, or that they can have emailed to them.
They're
That
not
is how-
provided them. They're just told if you do something else, you can find it. And with respect to getting them in written form, they're not even told that.
Respectfully, again, Your Honors, it is merely, abstract supposition to assume that veterans don't know, because again, no allegation has been made about the clarity of this notice. So I think for the purpose.
But that's the
of this-
process that you rely upon in inserting that the secretary fulfills the statutory requirement to furnish forms. That's the title of the statutory section, furnish
Yes.
forms, not
And-
furnish a standardized letter, point to forms, make them available if you have internet access or anything like that.
That is correct, Your Honors. The Secretary has an obligation to furnish forms. Not in every case, whether a form is in fact furnished will depend on a case-by-case basis, to the extent that furnishment is satisfied at the point of actual receipt. The manner in which the Secretary does that has no bearing on receipt, because again, even properly mailed forms, which is what petitioners want, can be lost or misdelivered. So even in those cases, actual receipt is not guaranteed. What it is the Secretary's obligation to ensure that at the end of the day, every veteran has what they need. And he starts this process at the initial point of entry, when veterans who don't.
That's not how injury is measured, whether it's more severe than the range of potential injuries that could occur just because stuff happens. Come on.
Your Honors, I'm not sure that the statute doesn't specify how the Secretary has to carry out his obligation. And even the petitioners at this point appear to concede that there are any number of ways that he can do that. And they use a standard, at least in their class action response, that is reasonably.
So that's why we're discussing whether the means that have been chosen are adequate. And there's been no explanation as to how that could possibly be so.
Your Honors, if I may, and I see my time is whittling.
Well, don't worry about your time. Just continue to answer the questions, please. Take whatever time you need to what in your mind is a satisfactory answer to our questions.
Your Honors, when the veteran engages the system, their abilities are going to typically dictate the manner in which they engage the system, at which point their abilities will be assessed and they'll be offered a paper application if that's what they want. If they're offered one, perhaps by mail, by fax, by email, or in hand, only in hand will they immediately receive it. In every other instance,
But there's nothing in the communication that the veteran receives to indicate that a hard copy form is available and here's how you get it.
And Your Honor, if there is legitimate confusion amongst the veterans population, then it's perhaps something that the Secretary is certainly willing to consider. But I would suggest that there may be good reasons why it's not. And one of those reasons may be because veterans are not confused, because when they do call, this is not an issue of confusion for them, that they have not indicated to any of their service representatives that this is a point of confusion for them.
Is it?
Just a minute. Sorry, Judge Jaquith, go ahead.
Isn't that a basic notice and opportunity, due process, fair process requirement?
If veterans are harmed, Your Honors, that is a matter that can be approached. But right now, we don't even know that the Secretary If a veteran is not furnished with the form by any definition of that, even if it's mailed and they don't receive it, we do not even have an allegation that the secretary would deny that veteran any monetary benefits because of that failure to furnish that form. That secretary certainly has remedies within the system to make good on a failure to furnish a veteran with forms. We are simply not here. That's not this case. For example, if the secretary tries and fails, maybe that 1 year period could be equitably told. Maybe in other instances, the veteran could nevertheless receive the full amount of benefits to which they were entitled. And the secretary should have that option.
Anything's possible, but you wouldn't want a veteran counting on those equitable tolling and other means based on the secretary's failure when there's a statutory requirement. If it's complied with, we don't have to worry about those kinds of things.
And we
Doesn't the system that the secretary has chosen violate the statutory obligation to furnish the forms free of all expenses by putting the cost on claimants and prospective claimants, by channeling them to electronic communications, which require expensive equipment, costly internet service, or travel to find equipment and service available for public use, and then payment to have documents printed?
They can call a toll-free number and also get them. In fact, Your Honors, they can walk into an RO and get a paper application on that spot. And that alone, Your Honors, arguably might even satisfy the obligation to furnish is, yes, come to me and I will hand you the application that you want. Your Honors, the secretary goes greatly beyond that to ensure that everybody gets what they need. And again, Your Honors, we're here talking about a hypothetical because we don't have a situation where anybody has been denied the very thing that they wanted. So, Your Honors, this petition suggests the system works.
How do you know that, counsel? How do you know that?
That
no one's been adversely affected by this system. By the way, how many regional offices are there? There's one per state with a couple of exceptions. You expect every veteran to walk in from the middle of their state to the regional office to get this form, when it would be just as, perhaps more convenient for the secretary to adhere to the statute in the first place?
I think the majority, I think the majority of veterans would acknowledge that the most convenient way to get their applications is to go online to get them, and recognizing that some may not be able to. Again, they can call. They don't have to walk into an RO. They can call any number of places. And again, there are over 100 recognized and nationally recognized VSOs that they can work with represent millions of veterans. These two veterans are included amongst those. So if we look at this totality of the system, veterans are highly represented by VSOs.
But the furnishing obligation is supposed to be at no expense to the veteran, and for all veterans, regardless of their age, disability, income level, household composition, residence in a rural or urban area, all factors that affect whether veterans have access to the internet and the equipment and capability to make effective use of that access, or access to an RO or a VSO or any other thing.
Your Honor, I believe the interest that Congress sought to protect, that the Secretary sought to protect, is the ability to apply for benefits. There has not been an allegation by anyone that they have not been able to apply for benefits because of what the Secretary's done, which, Your Honor, I believe is why it is critical to address the question of injury before addressing the merits, because otherwise we are talking about hypothetical people who may or may not have injured. We don't even know. Your Honors, if this is a great problem, if this is a problem that extends throughout the country, then, Your Honors, I assure you, the Secretary would likely take action independently. But this is not an issue that I'm aware that has been brought up. That this is litigation has offered two examples that don't even fit the mold of what they're trying to seek. So, Your Honors, I don't believe that it is a problem. I do not believe that any veterans have been denied monetary benefits.
So that's how disabling the injury has to be before a remedy is available? Look,
By
even if-
constitutional
even-
standards, it has to be more than a mere allegation that a statute has been violated. So
Even
we
if
need something.
sacrificing a few for the benefit of the many is may be required in war fighting, don't we owe those who sacrificed and survived a paper form, or at least the opportunity to get one so that they can apply for the benefits they deserve?
Your Honors, I am not aware of a situation where a veteran believes that they have actually been denied the ability to pursue their benefits. And I would agree with you, Your Honor, sacrificing the few for the benefit of the many may not be the best policy, but that is not the policy. There is no one who is alleged to have been sacrificed here. The two petitioners here have what they want. They got it free of charge. They were able, they have precisely what they want. And there's been no allegation that there is of anyone who has not. And if that person exists, if there are people out there or any groups, then Your Honors, we can revisit this. And in fact, the Secretary presumably would revisit it because it would potentially be an issue, but it's not an issue here. And there's no assertion of the existence of any group of people who have been harmed by the Secretary's practice.
Well, if the court agrees with the petitioners that VA's standardized letter and the process that you've described and is described in the briefing does not fulfill the requirements of 5102A, how should the requirements of Section 5102 be fulfilled?
Well, it's our position that Congress did not include any caveats on how things can be furnished, and nor did it even say that forms couldn't be furnished online. If there is a if there are individuals who are in fact slipping through the system and who are in fact being penalized by that, then Your Honors, then the Secretary can take that corrective action when those individuals become known, so that the Secretary can assess why did these veterans slip through the cracks? How did the veterans slip through the cracks? And maybe, Your Honors, it would be by changing the language on the intent to file form. Maybe it would be by changing the language on the form template letter. There are many ways the Secretary could correct that, but we need that injury. We need to know that that exists and to understand why veterans might be slipping through the cracks before the Secretary can take action, and certainly before the court should take action based on these incomplete facts and hypothetical scenarios. Your Honor.
Well, an injury's been alleged. You just say it's not enough.
With due respect, it's our position that it's the courts that have said that the mere allegation of a procedural or legal is not enough, Your Honors. And again, I apologize. I'm not by any means intending to take a rigid approach here, and it is not the Secretary's position to take a rigid approach. The Secretary has gone to great lengths, Your Honors, to ensure that all veterans have what they need to pursue their claims for benefits. We believe that what the Secretary does is not only consistent with the law, but eminently reasonable. And to the extent should it arise that there is an identified group of veterans who are still slipping through the system, then Your Honors, if that is brought to the Secretary's attention, then it can be addressed at that time. And I apologize, Judge Greenberg, I have gone well over.
And I'll take whatever time you need to answer, but it's about time we stop repeating ourselves. All right. Now, any further questions from my colleagues? Judge Meredith, anything more for the government?
No, thank you.
Judge Jaquith?
No, thank you.
All right. I hate to do this, but I have one last question for the government, and then we'll turn to counsel. What about the overarching statutory duty to assist? Doesn't that come into play at the very beginning?
I do not believe that it comes into play until a claim is actually received, Your Honor.
So the duty to assist in perfecting the claim doesn't come into existence until the claim is actually made, and you believe that the facts here are not the making of such a claim.
That is correct, Your Honor. But I believe that, again, the Secretary satisfies more than his obligation, that he goes above and beyond in his attempt to cater to all veterans.
Thank you very much.
Your
All
Honor.
right, we appreciate it. Thank you. Anything further you'd like to say on behalf of the Secretary?
Only that, Your Honors, that the Secretary's practice is to furnish applications to veterans, and to provide paper copies to those who need or want them. That is his practice. He does that, and there's no impediment to obtaining those applications.
Thank you very much.
Thank you.
We understand your argument. Appreciate it. All right, we'll turn to counsel for the petitioner. Go ahead.
Thank you, Your Honor.
Why
First,
don't you, if I may, why don't you focus on the colloquy had between my colleague, Judge Jaquith, and counsel for the secretary before you begin your reply. What's your position on that?
I believe that when you refer to the colloquy, you're talking about is the process as a whole sufficient to satisfy the statutory obligation?
Well, answer it however you want.
Okay. Well, that is what I was about to address, which is the secretary, the premise of the secretary's argument is that the practice as a whole is designed to catch people who need or want a paper application. And that is just not the case. As for people who submit an intent to file by paper form, they don't have contact with the VA, so they don't have the opportunity to be assessed for their need or desire for a paper application. And because the letter that they receive in response does not indicate that getting a paper application is an option, there are a number of people like the late Mrs. Murray who do not realize that there is anything that they can do to go get the application in some other way. And so that subset of people is, there's a problem there. That as to the secretary's argument that people who get the forms in the first place from a VSO, the secretary cannot shift his obligation, which was imposed by Congress and is in the statute, to the VSOs to offer paper applications. The secretary's obligation is to furnish them in a manner reasonably calculated to be received. He cannot shift that obligation onto the VSOs, who, by the way, I understand are incredibly overworked and may not have the capacity to track whether each person has submitted an ITF and what they have gotten in response. The secretary also in his briefing talks about if you have submitted an ITF orally, that they are supposedly, the call center representative supposedly assesses this person's need. The only evidence that he has put forward in support of that is hearsay from an unnamed VA representative, and then a heavily redacted internal guidance document about which he provides basically no context. We don't know who has access to that document, how long it has been in existence, who is trained on it. And when you read the language of the internal guidance, it's written in the disjunctive in any event. And so even if a call center representative offers, someone calls in with an ITF and says, I'd like to file, they can satisfy this internal guidance document simply by referring the person online. It only instructs the call center representative to tell them about e-benefits, refer them online, or offer a paper form. And so it's not even clear from the scant evidence that he has put forward that there is a practice of actually assessing people's needs. And to the extent that he's saying we don't have a case where anyone has not gotten the form and needed it. I mean, we would point to Mrs. Murray. She went almost an entire year, an 88-year-old World War II widow who was housebound during the pandemic. She didn't know that she could call. And so eventually her family and her counsel do step in at the last minute to provide her with a form. But for people who are not represented, this is a real issue.
Counsel, could I jump in there?
Yes.
I believe the government provided some evidence that Mrs. Murray was represented by her grandson, who was a VSO. Is that not the case?
That is the case. But again, for people who do not happen to have a family member who is, knows about this process, they don't have any way to understand what it is they're supposed to do. And so the secretary's answer for those people is figure out on your own that if you call and ask a second time or ask a third time that you will get what you're looking for. And so we would say that's not sufficient. As to the mootness, the Secretary argues that this is the system operating by design. And so therefore the mootness exceptions don't apply. This court in Godsey and the Federal Circuit in Monk recognize that the Secretary has a tendency to moot pending petitions, and so that claims against him are inherently susceptible to mootness. And again, you should not have to file a lawsuit in order to get the paper application.
Assuming that the petitioners satisfy or not knocked out by a mootness limitation, what about their adequacy as representatives of the class if their individual claims have been satisfied?
Yeah, so courts have dealt with this question and have found that the very existence of the picking off and inherently transitory exceptions disprove that there's an adequacy issue just because an individual's claims are mooted. And this court has in the past, for example, in Godsey, certified classes where the named petitioner's claims are moot. And so they possess the same claim as the class at the time when they joined the suit. And so therefore there is no adequacy problem presented by mootness.
Sticking with the class issues, how does the difference in potential injuries between claimants and prospective claimants, intent to file folks, affect the question of commonality here?
When you say difference in potential injury, could you clarify what you mean by that?
Well, in one case, there can be an effective date consequence, but in the other, there's no relation back to an inquiry, expression of an intent to seek a benefit.
Just because claimants or class members may be injured in different ways, some may suffer a more severe injury than others, does not defeat commonality here. They all suffer the same injury in that they are all having to take on this added burden to seek out the application form in a way that the statute does not contemplate. And so in that sense, they share a baseline common injury, and the fact that some may eventually experience a more severe injury doesn't affect commonality.
Have the petitioners engaged with the Secretary on the question of determining the breadth of the class? Who's received an intent to file, who the Secretary has received an intent to file or request for an application from and has neither delivered the forms or instructions nor received a completed claim or application for benefits, the way that you've defined the class in your amended petition, subject to the SCAR limitations possibly?
We have not engaged with the Secretary on trying to determine how many people we're actually talking about here.
Proceed. Counsel.
I think unless there are further questions, I would just conclude by making the point that I believe Judge Jaquith alluded to in part of his colloquy with the Veterans Affairs Council, which is that, to be clear, the petitioners are open to a range of ways that the Secretary can remedy this problem. We are not asking that paper copies necessarily be mailed to every single person, but he cannot pursue modernization at the expense of people for whom online applications do not work. He acknowledged that this was a problem in the rulemaking process. And so he can come up with a solution that both protects those people's rights and achieves his modernization goals. And that is all we are asking for here. Thank you.
Thank you. Anything, Judge Meredith?
No, thank you.
Anything further, Judge Jaquith?
No, thank you.
All right. Well, counsel have done an excellent job in presenting the case today and in your submissions before today. So we'll reserve opinion. The case is submitted.
And the court is in recess.